Yes, Mr. CT.
May I place your lordships?
Uh,
Item 7 on 26/5/2022. This matter was to be, an order was passed by this honorable court to list this case after disposal of one writ petition where the buyers of the rules have been challenged. The enactment has been challenged. That has been disposed of on 24/4/2024, last month. So this case is to be listed after the disposal of that case in terms of the order 26/5/2022. And thereafter, this matter has been listed for the first time. This case has got so many interrelated checkered history. Few cases are pending. So let this matter be heard after about 3 weeks, Lordship.
In fact, Your Lordship, in view of the disposal of the writ petition 92 of 2022, the judgment order, which has been mentioned by the senior counsel 24/4/2024, by the division bench where your lordship was also sitting as one of the members, lordship. There's nothing to survive in this, appeal.
That is,
Yeah,
anyhow, let us give him a chance. If he still feels that there is some points to be argued. If not, I am also having that. I'm also that. I don't know. If I'm right.
Lordship, after hearing me,
I'll be
everything will
convinced.
be revealed.
Okay, okay. So let us give him a chance. We'll give a date. We'll give a date. Yes, take a date.
Second week of June.
Okay. On the prayer of Mr. C.T. Jamir, the Learned Council for the appellant listed on
10th June.
10/12, on 12, on 12/6/2024. Okay.
May it please, Lordships. My
Yes,
lord, I beg to mention item number 19, 20, and 21, Lordship. That this matter will be listed after 2 weeks, Lordship.
here for the,
I'm for the petitioner, Lordship.
Lordship is a long pending case. If a date may be fixed, your lordship.
yes. Give a date.
Okay, 29, Lordship.
29 of May. On the prayer of Mr. So-and-so, Learned Council for the petitioner, listed on 29/5/2024.
May I please, Lordship?
Yes,
I beg to mention item number 14, Lordship. On behalf of my colleague, MS. If this matter can come up next week.
next week. Okay, ma'am.
Lordship, if this matter is taken as a fixed item, Lordship, if Lordship allows.
Next week.
Yes, Lordship.
Yes. On the, Mr. V. Jimomi, Learned Council makes a mention on behalf of MS. Livika,
Lordship.
the Learned Government Advocate and seeks adjournment of the case after a week. Any date listed on? Any date?
Wednesday, Lordship.
Listed on, that is 22nd,
Yes,
listed
Lordship.
on 22/5/2024. Okay.
Much obliged.
Pushed by item number 4. Item is subject to appeal on the beginning of the year.
Item 4.
Yes, please.
My lords, I appear for the petitioners in item number 4.
What about item 5? Item 5, whether notice. Whether notice complete?
No, your lordship.
Item 5, item 5.
Yes, lordship, I'm for item number 5.
You are the,
Petitioner, your
I am
lordship.
asking whether notice
Notice
served.
is not complete, your lordship.
Let us
Lordship,
see.
My lords, I have a small request in item number 4 and 5. If my lords may hear me.
Whether steps have been taken or whether anyone is appearing in item 5. Item 5, whether steps has been taken.
no, your lordship. Lordship, since the petition is very thick and then the postal stamp, the requisite is not available. So I may be allowed to serve the copy by hand today itself.
Who is appearing? Who is authorized? Are you authorized? They are not authorized. They are authorized to appear in item 4. But item 5, I think they are not, I think no one has been engaged.
Then your lordship, I'll take steps by today itself. then.
Yes, ma'am. What is your?
My lords, there are 2 orders in item 4 for expedited hearing on 7/2/2024 and 29/11/2023. With the incoming of item number 5, the hearing is going to be delayed. My request is to either treat it as an interlocutory application so the matter is expedited as soon as possible.
No. That cannot be. Since it is a writ appeal, let them take steps. They have not even taken steps for service of notice.
My lords, they were not party in the High Court in the single bench.
But this court has allowed them to. There's allowed leave to appeal. Okay, Mr. Younger, you are,
Lordship, earlier, Mr. Kohima
you are for,
AG.
you are for,
For the Union of India,
in which case?
in item number 4.
For.
Yes.
What about 5?
5, I don't know whether we are a party or not. That's in the petition.
Ah, okay.
Lordship, I'm appealing for respondent number 6 in item number 4, the Kohima Municipal Council.
Okay, this, you are for item, petitioner,
Yes, Your Lordship. Item number 5.
item 5,
Yes,
okay,
Your Lordship.
okay. And you are for the petitioner in item 4,
That's correct, my lords.
okay. Third, MS Senso. Learned counsel for the, your good name,
Sadamini Sharma, my lords.
MS Senso, Shalini, your good name?
Sadamini Sharma, my lords.
Sudhamini Sharma, heard MS Sudhamini Sharma, learned counsel for the petitioner. This is in this,
And then,
2023, okay?
appellant, no?
Appellant number 1 and 2.
Learned counsel for the appellant and Mr.
For the 1 to 3.
L. Iralu, the learned counsel for the respondent number 1 to 3,
Lordship, I'm for the same.
MS Koma, MS V. Sokre, learned additional advocate general for the state respondents,
Lordship, I'm
And-
representing respondent number 7 and 8 for item number 4.
MS Soitso, learned counsel for the respondent number 7 and 8, and Mr.
Tilongjam for 6, my lord. Respondent number 6.
Mr.
I am not in the petition, so I don't know.
Mr. How can you be so casual? Mr. Imti Longjam, learned counsel for the respondent number,
6, my lord, in item number 4.
yes, and Mr. Yangarwati CGC, and Mr. Yangarwati CGC. Stop. Please take the WA 7/2023 along with WA 12/2024. Okay? In
My lords. I'm sorry, my lords. My lords, last order, the FSSAI
in
counter.
12A, in WA 12, so and so, 2024. Yes, who is the petitioner in read appeal 12?
My lord, Tiyakrala, Miss Tiyakrala.
MS.
Item 12, we are the petitioner.
Learned counsel appears for the appellant and submits that she may be allowed to take steps upon the respondent number 1 to 10. Respondent number 1 to 10.
No, Your Lordship. Respondent number 1, 2, 3, 6, 7, 8, and 9 and 10.
1,
1, 2, 3.
1, 2, 3.
Yes.
What about 4? Why not?
4 is the state. I have served already. Yes. 4
Four.
and 5 is the state, Your Lordship.
5 state, 6, 6,
6.
1, 2,
MC.
3.
6.
Whether you have served 6,
No,
No,
my lord.
6, then 7,
8, 9, 10.
8, 9, 10.
Yes, Your Lordship.
MS Swenson, learned counsel for the appellant shall take steps for service of notice upon respondent number 1, 2, 3, 6, 8, 9, and 10 by registered post with AD within a period of
2 days, Your Lordship.
2 days from today.
Yes.
MS Rees-Ockrey, Leonard, the Additional Advocate General, appears for the respondent number 4 and 5. Who is for 6?
Lordship. 6,
The 6 is KMC, Kohima Municipal Council, Your Lordship. No,
Have
I
you
have,
served?
no, Your Lordship, I have served the copy to respondent number 4 and 5 only. The state.
MS so the Learned Council for the, okay, just correction, okay, appellant shall take steps for service of notice upon the respondent number 1, 2, 3, 6, 7, 8, 9, and 10 by registered post with AD. MS Rees-Ockrey, the Learned Additional Advocate General, appears for the respondent number 4 and 5.
Obliged by.
The notice of service will be taken within a period of 2 days from today.
Yes, Your Lordship.
Obliged.
Listed after
3 weeks, my lord.
3 weeks. Listed after 3 weeks.
My lords, the counter affidavit for FSSAI had to be amended and filed. To my best knowledge, hasn't been filed yet.
Okay, next. Okay.
Obliged.
Worship, I have a prayer for the appellant in item number 4, Worship. The counsel for the council's name, Shreya Paropkari and MS Pinky Anand, Senior Advocate, may be reflected in the cost list, Worship.
The name of Mr.
Shreya Paropkari
So-and-so
and MS Pinky Anand, Senior
and Mr.
Advocate.
So-and-so, Learned Counsel for the appellant shall be recorded in the daily cost list. You give the name to the
Lordship.
piece. Okay. Okay.
Obliged.
Right.
Your Lordship, in item number 4, in last order, the court has ordered us to file amendment affidavit. Respondent 7 and 8.
Amendment affidavit of what?
Yes, for counter affidavit by the opposite party, 7 and 8. And we have filed the affidavit this morning itself.
Let us see 4. On behalf of respondent number
7 and 8.
by which order? In item number 4. Read by last, continue, last line. By the order dated 18/4/2024. Learned Counsel for the respondent numbers 7 and 8 was allowed 2 weeks' time to file amended counter affidavit. Stop. MS so-and-so, Learned Counsel for the appellant submits that the amended counter affidavit on behalf of respondent number 7 and 8 has been filed only
This morning.
this morning. Stop. The amended counter affidavit filed by respondent number 7 and 8 is however not on record. Registry to trace the same and plus on record. Okay.
Much obliged.
Members, Lordship.
Yes, please.
Lordship, I beg to mention item number 9, Lordship.
Ah,
Lordship, here, notice on the respondent number 5, Lordship, I'll be appearing for respondent number 5, Lordship.
Fine.
They have to board, Lordship. So, Lordship, I'm be given 4 weeks' time. In the meantime, I'll file my power of attorney, Lordship, of Bagalatama.
We object, my lord. Am I being heard, my lord?
you are for which item?
Item number 9, my lord.
Item 9, just wait. Yes,
Lordship, 4 weeks may be granted, Lordship.
okay. You are for,
I am for the appellant.
you are for the appellant.
My lord, I'm senior, I'm virtually appearing from Kolkata, my lord.
I can
Ma'am.
see it. I am just asking you, you are appearing for which party?
I am appearing for the appellant.
Appellant.
Milord, this case is pending for the last 6 months for admission only.
Lordship, the
Milord, this case maybe they have been given dusty service, home service, post service, but they are not appearing for the last 6 months.
They have received the notice just recently.
No, Milord, at least 15 days back, my junior will be telling.
The record will speak, Lordship. The dusty service was affected only in the month of February. We have received, and now today is listed today only.
How long, Milord? Only 2 months. Let this be admitted, Milord. Let this be heard.
The record will speak.
It cannot be as per your wish. Let
Milord,
us,
I'm praying,
let us go
Milord.
as per the procedure.
Milord, I'm praying. I can pray, and I'm not wishing, Milord. I'm just praying, Milord.
Don't pressurize the court.
By prayer, if making prayer is pressure, Milord, then I am helpless. 6 months have passed, this matter is pending.
Just wait. Please don't submit now. Let us see the record.
Milord. Milord.
Lordship, I can see the order dated 23 to 24.
I am on that.
Yes. Thereafter, the matter is listed only today, Lordship.
Third, Mr. You are
Metaphor, Lordship.
learned counsel for the appellant. Who's for the state? Mr. V. Jimomi, learned counsel appearing for the state respondents, and Mr. Zatin Mule, learned CGC, appearing for the respondent number 2 and 3. On 23/2024, the learned counsel for the appellant had submitted that after effecting the service of notice upon respondent number 5, by way of dusting, a compliance affidavit has been filed.
Lordship.
Stop. Thereafter, the matter has been listed today. Mr. N. Muzi, learned counsel appearing for the respondent number 5,
Lordship.
submits that he will be filing power and
Lordship, the matter can be listed for hearing. After
he
4
will be
weeks.
filing the power within a period of
A week's time, Lordship.
within a period of 7 days from today.
Lordship.
Since all the parties are represented,
Lordship.
all the parties are
Yes,
represented,
Lordship.
listed for hearing after 3 weeks.
Lordship, there are two analogous matter along with this, Lordship. Read appeal number 14 and 17 of 2023. So if these two,
WA 14,
14 and
14
WA
of
17,
14 of
2023,
2023 and
17 of 2023.
17 of 2023.
Similar matter.
List the present writ appeal along with WA 14/2023 and 17/2023.
Lordship.
Obliged, my lord.
All right, Milord.
Yes.
May I please, Your Lordship? Lordship, I'd like to mention item 8, Lordship.
Yes.
Lordship, I pray Your Lordship be gracious if this matter come up after 3 weeks, Lordship.
You're the counsel for the
Petitioner.
on the prayer of Mr. Senso, learned counsel for the petitioner, listed after
3 weeks,
3
Lordship.
weeks. Okay.
Lordship, there is an interim here.
The interim order passed earlier shall continue till the next returnable date.
Much obliged.
Yeah, please, Your Lordship, I beg to mention item number 10.
Ah.
Here, state is yet to file affidavit, so kindly grant me 2 weeks' time.
Yes, Mr. Mua.
I have no objection, Lordship.
MS AIME, the Learned Government Advocate, 6 for 2 weeks' time
Yes, Your Lordship.
to file affidavit in opposition. Prayer is allowed, listed accordingly. Okay.
Much obliged, Your Lordship.
Your Lordships, I beg to mention hearing item number 13. I pray that the matter may become after 3 weeks, Your Lordship.
What is this review?
Your Lordship, here, Your Lordship, the petitioner husband, Your Lordship, is seeking for service regulation just for the payment of pensioner benefits, Your Lordship. And then in the writ appeal, Your Lordship, it was
Is
disposed.
it the order passed by any one of us?
Yes, Lordship. Order dated 2/11 of 2022, Your Lordship.
Okay, when do you want it? Let
Lordship.
this be the last chance.
Yes, Lordship. 3 weeks, Lordship.
You're the counsel for the, on the prayer of Mr. Subhamwati Wali, learned counsel for the petitioner, listed after 3 weeks. It is made clear that there shall be no adjournment in the case. Okay.
Obliged, Lordship. Obliged.
May I please, Your Lordship?
Yes.
Your Lordships, I beg to mention item number 11. Here, the paper book has been already prepared. Therefore, I pray that this matter may be refixed for hearing.
Okay, ma'am.
Yes, Your Lordship, after 4 weeks, Your Lordship.
MS. So and so, learned counsel for the appeal admits that the paper book is ready and the matter can be listed for hearing. Listed for hearing after 4 weeks. Okay.
Obliged.
For motion, item number 1.
May it please, my lords.
Yes.
Lordships, I have a very limited prayer
Ah.
in this instant with petition, Lordship.
Yes,
My-
madam. Whether the representation is under consideration.
I've been verbally informed by the respondent number 3 that his representation has been forwarded to the government. Respondent number 2,
Who is out to?
the Home Commissioner,
By whom?
by the Directorate of Prison.
Does it suffice?
Your Lordship.
Lordship, after that, Lordship, as per the notification which I have annexed, the government must consider my representation, Lordship.
But as per the last order, what was that? Is under consideration.
Yes, Lordship, so if a direction can be given for considering my representation within the time frame period, Lordship. Earlier also, Lordship, in similar matters, Lordship, a single bench of this honorable court has directed to dispose the representation within a period of 5 months, Lordship, in 2 earlier cases, which I have handled, Lordship, when I was the Legal Services Council, Lordship, before this honorable court.
Response is still awaited from the Honorable President of India. Has it, is this matter supposed to go up to that extent?
Lordship, he has
President
an-
of India on mercy petition.
He has an option, Lordship, but Lordship, if I may be allowed to rely on a single citation that I have placed before my lords. 2019-14 SCC paragraph
This
22.
is a conviction by the Armed Forces Tribunal.
By the court martial.
By the court martial.
Yes, Army court martial, Lordship. After that, AFT have dismissed his appeal, Lordship. And after that, he went before Honorable Supreme Court. There also, he was not successful, Lordship. Both on the issue of delay and on merits, his appeal was dismissed. I have annexed the orders, Lordship.
What was that time? What was that time? Supreme Court?
Supreme Court, Lordship, if I may.
That means Supreme Court has rejected your premature release.
No, Lordship.
Or-
On merits, he went for appeal. Not on
On
premature.
merit, on
Yes,
merit,
yes,
on
yes,
merit.
Lordship, yes. Now, here I am approaching this court on the ground. I have submitted the representation before the state government on the ground that I have completed 14 years of actual imprisonment without remission, Lordship. And that qualifies me for premature release, Lordship, as per the Government of Nagaland Home Department notification dated 16 May 2001.
Okay, let us see the facts first. Let us see the facts first, and let us see. Let us hear you on facts.
Lordship, the facts in the gist is that by judgment and order dated 13/8/2012, Lordship.
Which is that?
Lordship, that we were unable to obtain that, Lordship. But since that is not under challenge in this instant petition.
I
Lordship.
want to know the facts. That's why
Now-
whether you are whether that is under challenge or not, it's not your concern.
Lordship, and then Lordship, after that, since I was convicted by the court martial court, I approached the Armed Forces Tribunal Regional Bench at Gauhati, Lordship. And the Regional Bench Gauhati dismissed my appeal, Lordship, which I have annexed at Annexure
When
2
was the first order passed? Kindly tell us.
on 13th of August
Where have you
2012.
stated that?
Lordship, it is stated in Annexure 4, both in Annexure 4 and 5, the date is reflected, Lordship. Of course, I have stated in my writ petition also.
Yes, we want it from your writ petition. Which para? Para 5.
Yes, Lordship, paragraph 5, Lordship. He was convicted under section 302. And thereafter, Lordship, he filed an appeal, original appeal application 08/2014 before the Armed Forces Tribunal Regional Bench Gauhati. But the same was dismissed, white judgment and order dated 1/10/2015. After that,
Yes, and
Lordship,
where is that appeal para 6?
paragraph 5, Lordship.
What about dismissing your appeal? Para 6.
Yes, this is the Supreme Court appeal, Lordship. It was dismissed by order dated 3/1/2019.
You were convicted under 302
Yes, Lordship. under
by
302.
the General Army Court Martial.
Yes, Lordship.
And you appealed against this before the Honorable Supreme Court.
No, Lordship. I initially approached the Armed Forces Tribunal Regional Bench Gauhati. Yes.
OA.
Yes, yes, Lordship.
Okay.
That was also dismissed. Now against that,
Just wait. Don't rush things. Okay, after your appeal was dismissed in OA 8,
yes,
you
Lordship.
approached the Honorable Supreme Court.
Yes, Lordship.
This was on merit.
Yes, this was
On
on
merit.
merit, Lordship. Yes.
Yes, so it was dismissed.
Yes, it was
Thereafter, what
dismissed.
happens?
After that, Lordship,
The petitioner finding no option to file any appeal or revision before dismissing
I-
the appeal for mercy petition.
yes, Lordship, before the governor.
Yes.
Now, all these developments,
So,
Lordship,
so what happened? What is the result of this mercy petition?
no outcome, Lordship.
Thereafter,
Thereafter, Lordship, I completed 14 years, Lordship. Now, till the stage I submitted mercy petition before the governor, I had not completed 14 years of actual imprisonment.
okay.
So I could not have submitted the present representation, Lordship. So after I completed 14 years of actual imprisonment, Lordship, I submitted a representation before the state government, Lordship, on 8th of March 2024, Lordship.
Where have you stated that?
At
Para
paragraph
8.
8, yes, Lordship. I have been taken under custody, Lordship, on 5th of November 2009 and have completed actual imprisonment of 14 years on 5th of November 2023.
You were taken, where have you stated that?
At paragraph 8, Lordship. Subpart, the subpara, Lordship.
1511.
Yes,
Has been
511.
511.
Yes, Lordship. 5/11/2023, I have completed 14 years of actual imprisonment. And I am presently lodged at Central Jail, Timapur. Now, Lordship, I have reproduced the relevant portion of the Home Department Government of Nagaland notification at
Let us
paragraph
see
8.
that. Let us see that.
Yes, Lordship. I have annexed the type copy at page 39, Lordship. The relevant portion is at page 40, paragraph 3.1.
Page
40, Lordship.
Page 39.
Yes, it begins from 39. Relevant portion is at page 40, Lordship.
This is the notification issued by the Home Department.
Yes, Lordship. Government of Nagaland Home Department, Home Branch.
Yes.
Now, if I may be allowed to read 3.1, Lordship. Page 40. Paragraph 3.1. Paragraph 3
At
is
page
at page 40, my lord.
40.
Yes.
3.1.
40, yes.
3.1.
Yes. Now, eligibility for premature release.
Ah.
The following categories of inmates shall be eligible to be considered for premature release by the Sentence Review Board. 3.1. Every convicted prisoner, whether male or female, undergoing sentence for life imprisonment and covered by the provisions of Section 433A CRPC shall be eligible to be considered for premature release from prison immediately after serving sentence of 14 years of actual imprisonment without remission.
You have not availed remission.
No, Lordship. I have completed actual imprisonment
14
of
years without remission.
Yes, my lord. And Lordship, at paragraph 4, Lordship, the very next page, Lordship, at page 41, they have given inability for premature release. These are the categories. They have given 4 categories, Lordship, where a prisoner shall not be eligible for premature release. I do not fall under any of these 4 categories, Lordship.
What about 4.2?
No, Lordship. No. This is deals with organized murder, Lordship. Organized murder, Lordship, it cannot be it cannot be done by a single person. Now, my lord, if I may be allowed.
Just wait. Yes.
My lord, if I may be allowed to rely on a single citation, Lordship.
Just wait, recommend. So your case in brief is that actually the representation submitted by you on 8/3/2024,
Yes, my lords.
after completion of 14 years of actual imprisonment without remission,
Yes,
has not been considered
yes,
by the Home Department as of
yes,
yet,
lordship, yes. And
in the light of that notification.
Yes, my lord, my lord is absolutely right.
Okay. Okay, where is that Supreme Court judgment? Let us see.
2019 14 SCC 114 at paragraph 22.
2019. SCC 11. Which para, Santi?
22, my lords. If I may be allowed to read.
Yes, wait.
Page 125.
125.
Yes, lordship.
Yes.
We therefore dispose of this petition with a direction to the competent authority to process the representation made by the petitioner dated 5/2/2018, Annex Year B6, and take it to its logical end expeditiously and preferably within 4 months, in accordance with law, without being influenced by the rejection of the earlier representation right order dated 14/6/2010 by the state government. We also hold that consultation with the central government would not be necessary, and the state government, being the appropriate government, must exercise powers conferred upon it in terms of sections 432 and 433 CRPC. All questions to be considered by the appropriate government are left open.
So this is irrespective of conviction by the statutory courts or the military?
Yes,
courts?
yes, lordship, yes.
Are you very sure?
Yes, lordship. Lordship, in fact, lordship, at the single bench, Justice Manish Chowdhury, he has also disposed of a similar writ petition, lordship, at the motion stage, if I may be allowed to place the. This was a legal services matter, lordship.
Huh.
The last page of the order, I may be allowed to read the last paragraph.
But these were all conviction by the statutory courts. That is why this was decided by the single bench.
Yes, lordship. Yes.
This is by the Armed Forces Tribunal.
No,
Why actually this petition is before this court?
lordship, it's, I think earlier, lordship, I ought to have approached the division bench, lordship, because for sentences
So these
above
are
10
all,
years and above.
these are all judgment passed by a single judge without
Yes.
jurisdiction.
Yes.
How can I rely on this?
Lordship, lordship, it should have been placed before the division bench, lordship, but the single bench took up the matter, lordship. As per rule 7A, I think, chapter 2 of the Gauhati High Court rules.
No, this was conviction by?
The.
In the case decided by the single bench? This was, this
District
is
and
a,
Sessions Judge.
this is a police case.
Yes, lordship.
This is a police case.
Yes, lordship. But the same notification applies. Here also.
Same notification, but the thing is that earlier, I think the competent forum was not approached.
Yes.
Okay.
Now, if I may be allowed to.
No.
My lord.
If it is not by a competent forum.
My lord, my lord.
Let us only rely on this.
My
Supreme
lord,
Court.
my lord.
Okay.
Yes.
Okay, we pass order. Heard Mr. Sinthiang. Yes, I'm sorry. Yes, Ms. Mary.
I'll leave it to your lordship.
Yes, we are not passing any order adverse to the government, just for consideration of the representation.
Yes.
Okay,
Yes.
in terms of the notification.
Yes.
Okay. Heard Mr. So-and-so, Santhianga, learned counsel for the petitioner, and MS Mary, then a senior government advocate for the state respondents. Okay. We pass the order in the chamber.
Much obliged.
Yes, this also.
For motion, item numbers 2 and 3.
2 and 3. Yes, Mr.
Yes,
Hey, Dimumi.
Yes, my lord. So this is the second PIL with regard to the same subject matter, right? Also require the issue of National Highway 129A and 329A.
Mr. Jimomi, in this IA,
Yes, my lord.
they have actually sought for deleting Is it like that? They have
Yes.
sought for deleting
They
and.
want to be struck out from PIL.
And on the last occasion, your juniors, they have sought for some time to file written objection.
I filed affidavit.
Okay,
I filed. I have to copy. So copy both to the central government as well as the council for NHIDCR.
your affidavit is not on record.
We'll be filing together. I've just.
Yes, we list it next week. Next week. You have not filed the affidavit. You have not filed the affidavit.
We'll file it today.
You'll be
I was
filing,
under the impression it
okay.
was already filed.
Mr. A. Jimomi, the learned counsel for the opposite parties, correct?
Yes, my lord. I
Submits that the affidavit objecting to the application will be filed in the course of the day. List the case on next
next week. Automatically next Wednesday will come up.
22. List the case on 22/5/2024. Okay.
Much obliged.
From the supplementary cost list for motion item number 22.
We issue notice. Mr. Wati Jamil. The learned counsel for the appellant. Stop. The present writ petition has been filed. Impugning the judgment and order dated 24/4/2024, passed by the learned single judge in WPC number 258K of 2022. Issue notice returnable after 4 weeks. Since Mr. Senso, Learned Government Advocate accepts notice on behalf of respondent number
1 to 6.
1 to 6. No formal notice need be issued to the state respondents. The learned counsel for the petitioner appellant shall however serve the requisite copies of the appeal petition to the learned government advocate within
3 days.
within a period of 3 days from today. Insofar as the respondent number 7 is concerned, the learned counsel for the appellant shall take steps for service of notice upon the said respondents by registered post with AD within a period of
1 week.
within a period of 7 days from today.
Lordship, there is a IE.
Yes.
However, I breathe on Lordship, instead of staying the immune judgment and order, Lordship.
No stay.
A prediction may be given because anytime the primary respondent number 7 case for promotion may be considered.
That
Such
was
a case
that
is
was not the
Lordship.
case. That was not the case in the single before the single bench.
Once the R7 is given a further promotion.
Once you succeed in the appeal, everything from top to the bottom goes.
Lordship.
Yes, okay.
For admission item number 6.
Yes.
May I believe your Lordship?
Ah.
Lordship, by the order 24/4/2024.
24/4?
2024.
Let
State
us-
respondent,
Yeah, just wait. The file has become so bulky that we
has.
have to make part file.
It has my lines.
In some part, the orders, in some part, the affidavits, in some part, the petitions. get a order file. Order file is there. Yes, Mr. MT.
Your Lordship here, I find
Which
one-
order? Which order? Let me.
24/4/24.
24/4.
Here I was allowed to file additional affidavit in connection with the affidavit file on
24/4. Huh. 24/4 years.
Yes, I was allowed to file additional affidavit in connection with the affidavit file on 10/4/2024 regarding the meeting between the state respondent and the NHIDSL regarding the acquisition and requisition of the land. So here I was permitted 3 weeks, but because of my personal problem, I could not file the additional affidavit. So
Additional
also,
affidavit for what, Mr. MT?
in affidavit which I filed on 10/4/2024, I could not accommodate some more documents. So I have taken permission to accommodate that those
That
documents.
additional affidavit was for the purpose of laying before this court the meeting regarding acquisition.
Yes,
requisition.
regarding the
Yes.
acquisition and requisition.
Your Lordship, what has happened is this.
Uh-huh.
Earlier, the government had taken a decision. There was a letter written by the Chief Secretary to the effect that for the construction of national highways, no land compensation will be paid. That circular, that letter has been withdrawn, and the government has taken a decision that henceforth, for construction of national highways, land compensation as well as damage compensation will be paid. So some clarification was sought from the state on that point. So
Okay.
that is the addition, that is why the additional affidavit is necessary.
Okay, that is on requisition acquisition of
Acquisition,
the land by the
yes.
government.
Yes.
Or by the central government.
By central government, Your Lordship, but through the state, of course.
Okay, okay. But Mr. A. Jamumi, Leonard Amicus Curie, Mr. Im Tim Sung, the Leonard Additional Advocate General for the state respondents,
Respondent number 3, 4, 5, 6, 7.
for the state respondent number 3 to 8,
3 to 7,
3 to 7,
11 and 12.
11 and 12. Mr. Joshua Shaki,
Respondent number 9, Your Lordship.
the Leonard Counsel for the respondent number 9. Mr. Sintianga, the Leonard Counsel for the respondent number 10, and Mr. Moa Jamir.
1 and 2.
1, 2, and 8. Leonard Counsel for the respondent number 1, 2, and 8. Mr. Im Tim Sung, the Leonard Additional AG, submits that he may be allowed some more time to file additional documents on the
issue of land acquisition
by the central government.
By the central government, yes.
By the central government / state government.
Yes.
By the central government / government, as ordered by this court on 24/4/2024. Prayer is allowed, listed.
On the 12th, Your Lordship, on the 12th.
12th June.
12th June. Why I am suggesting that date, Your Lordship, is as far as the contract is concerned, the time limit for completion is also 31st of May.
Okay,
So all those points can be taken into consideration.
okay, okay. Listed on 12/6/2024. Okay, yes.
Much obliged.
For orders, item number 12.
None appears on behalf of the appellant. Stop. Office note dated 13/5/2024 shows that return service report upon respondent number 2 is still awaited. Listed after 4 weeks.
For hearing item number 15.
Yes.
May I
Yes.
please your lordship. Lordship, item 15 and 16 are of same case and regarding the appeal.
What about 17? Different.
17 is of a different case.
Okay.
So lordship, this is a appeal against the impugned orders passed by the special NI court Dimapur dated 13/6/22, granting bail to the two of the accused relating to NI case number RC 02/2020 NI Gauhati. Lordship, criminal appeal 3 belongs to accused 4 and criminal appeal 4 regarding accused 1 of the same instant case.
But different cases. This item 15 is for accused 4.
Accused 4
And item 16 is for accused 1.
Accused 1 related to the same NI case of RC 2/2020.
Okay.
And we are challenging the impugned order passed by the special NI court Dimapur, which states and which grants bail to both the accused.
Where is that order?
In the appeal, the lordship will find in page number 21. Order dated 13/6/22.
Page 21.
21 lordship. And in page 26, in the last para, may I read lordship?
Yes, please.
According in view of the aforesaid, both the instant applications are allowed and accused Railung Narsakbi, accused 1, and Jinghom Muneo, accused 4 are hereby allowed to go on bail of rupees 1 lakh each with 2 surety. And continued lordship. And in criminal appeal 4,
This is in regard to accused 4. This appeal petition.
Yes, criminal appeal 3 regards to accused number 4, and criminal number 4 regards to accused number 1.
The one by one, let us go as per the
Okay,
this,
lordship.
criminal appeal 3.
Yes, lordship.
3.
Yes, lordship.
3. So 3 is for accused 4.
Accused 4. The present appeal arises against the impugned order dated 13.
Madam, it is the same judgment, same order.
Same order,
By
but
the same order,
different appeal.
Different appeals.
Okay.
Appeals are different, lordship.
Yes, yes. Okay.
The present appeal arises against the.
You are reading from?
From NIA.
No, from your appeal petition. You are reading from which?
From 3, from criminal appeal number 3. The appeal petition.
You are reading the appeal petition?
Yes, lordship. No, I'm just stating what are the facts in a short form.
Okay, explain.
This appeal against the impugned order dated 13/6/22 passed by the Special NI Court Dimapur on bail of respondent and accused Jinghom Munao accused 4, arrested on 5/7/2020 in the case RC 02/2020 NI Gauhati. Lordship, should I read the other para?
You have filed an appeal. What are your grounds of appeal against the order passed by the?
Lordship, our ground is that the charge sheet against the accused was filed under section 17 and under section 20 or section 18 of UAPA Act. And the order passed by the Special NI Court Dimapur did not recognize our grounds for objection. The learned Special NI Court Dimapur has failed to consider prima facie evidence against the respondent accused 4 and statutory mandate law under section 43D, subsection 5, subsection 6 of UAPA Act. Section 43D, subsection 5 states, notwithstanding anything contained in the code, no person accused of an offense punishable under section 4 and 6 of this act shall in custody be released on bail or on his own bond unless public prosecutor has been given opportunity of being heard on the application of such release. And the Special NI Court, considering the ground that trial has been delayed, granted the bail to the accused number 4. And in our criminal appeal, we have mentioned that it is not in our hands because the trial has been delayed due to the pandemic of COVID-19. And I also like to
Bail has been granted during the trial. Whether this bail has been granted during the trial period
yes,
or
yes, Lordship.
at which stage? What stage?
Evidence.
Evidence.
Yes,
And some of the evidence already recorded?
Yes, Lordship.
Okay.
That's why, Lordship, I also want to refer to the criminal appeal number 07/2024 regarding Gurvinder Singh, in which the Apex Court held that mere delay in trial pertaining to grave offences and involved in the instant case cannot be used as a ground to grant bail.
What is the ground of granting bail? Ground of
By
granting bail by the
Special
court.
NI Court. By Special NI Court.
Yes, yes. Let us see.
Lordship, we'll find it in page number 21. In page number 26, para 7, the learned special court states that considering the fact that the accused persons are in custody.
Page 26.
Page 26, para 7.
Para 7.
Should I read, Lordship?
Yes.
Thus, considering the fact that accused persons are in custody close to 2 years without trial having commenced, and with 105 witness proposed to be examined, there is no likelihood of the trial being completed with a reasonable time and with the facts of the instant case corresponding to the facts of the case laws above discussed. I am inclined to enlarge the accused person on bail.
Now, what is the progress of the trial now?
Lordship, the main problem is that the witnesses, there is very difficult to find the witnesses and bring them for the examination.
Now, what
So
about
we
the,
are-
what
we-
about the accused? Whether the accused are appearing before the court for trial?
accused are appearing before the court, but when they are released on bail, so there is very much possibility, and they can influence the witnesses, and there are some protected witnesses are also there.
What is the condition? Condition on the bail?
Condition. Associate, instant application, allow the accused person, accused 1 and accused 4 are hereby allowed to go on bail or
Not to leave the jurisdiction, will not directly or indirectly make any inducement. Have you found that they have induced any of the or threat to any of the witnesses?
we directly have not found, but since regarding some of the witnesses who are earlier agreed to appear and give their statement, and they also give their statement in 160 under 161, but now they are not willing, but it is difficult for the prosecution to bring them. So these kind of situations are
What I
happening.
mean, then this warrant can be issued against them. There is a procedure. They can
Yes,
be-
but we have not.
There is nothing, actually, you have not brought anything on record to show that these accused persons are influencing the witnesses.
We have not found any
Ah.
material evidence or something like that.
Is there any apprehension?
No, not.
What is your ground for then rejection of bail?
Because Lordship, there is a delay in trial, and for
Is it because of the accused being released on bail?
somehow they are.
How? Where have you
that's-
stated?
Right now, we don't have the actual evidence. But since both the accused have been charged sheeted under UAPA Act, and since Lordship, if refers to the Gurvinder Singh case, the Honorable Apex Court also held that bail is an exception when the case is registered under UAPA Act. So I am referring to this.
Anyway, whatever may be, rightly or wrongly, bail has been granted. Now,
Yes,
whether they have violated any of the bail conditions,
Right now, no. But we have not found directly any evidence. But somehow they can, or they may be influencing the witnesses because they have. they are not-
That assumption should not be there, that assumption should not.
anything else?
No, Lordship.
Yes, Mr. Ismail.
Your Lordships, the only ground, I mean, which the NIA has taken is that in view of section 43D, there is a prima facie case, so bail should not have been allowed. That's the only ground taken. Now, as far as I find an affidavit of opposition, there are 105 witnesses, Lordships, 105 witnesses. And after the month of September.
There's written objection?
And yes, Madam, I filed, your Lordships can come to my written objection. In fact, the facts are recited there. So can I take your Lordships to paragraph 3 of my written objection? May I read my note, just to place the facts so that the facts are very clear. Paragraph 3.1, the respondent accused number 4, along with the accused number 3, was taken into custody on 4/7/2020 by the SM Rifles near 5th Mile, Dimapur, from his vehicle. He was subsequently handed over to the Difpar police station. 2, the SM Rifles filed an FIR dated 5/7/2020. Thereafter, Difpar PS station registered FIR under section such and such. All the entire sections, Your Lordship. You can skip that, turn to the next page at 3. Page 3, Your Lordship. Subsequently, by order dated 8/7/2020, the order dates are important, Your Lordship. The case was handed over to the NIA. The NIA itself registered another FIR bearing number RC dated 9/7/2020. The charge sheet was filed by the NIA on 29/12/2020. Dates are important, Your Lordship. The respondent accused number 4 has been charged under section 120B, section 17 and 18 of the UAP Act 1967. Then paragraph 4. The charges against the accused were framed on 6/5/2022. It may be seen that from the filing of the charge sheet to the framing of the charges against the respondent accused number 4, there was a gap of 493 days. 5, after the framing of the charges, witnesses were summoned through the process of court on 6/5/2022. The first witness in the case, PW number 5, was examined on 17/6/2022. From the date of his custody to this date, over 2 years had lapsed. So when the first witness was examined, he was still in custody. Whilst in custody, an application for bail on behalf of the respondent accused number 4 was filed by order dated 28/6/21. The application was rejected on the ground that there was a prima facie case against him. From the date of rejection of the bail application, the first witness was examined by the Special Court NIA only on 17/6/2022, after about 1 year. 7, the respondent accused number 4 continued to languish in jail without progress in the criminal case registered by the NIA. As such, a subsequent bail application was filed. In this subsequent application for bail, the grounds taken were, these are the grounds, madam. The respondent number 5 accused had no knowledge of the contents of the package he collected from the accused number 5, and that he was only running an errand on the request of the accused number 1. B, on perusal of the charge sheet, there is no evidence of record to show the involvement of the accused, respondent accused number 4, for the commission of the offence alleged. The investigation could not establish the nexus between the respondent accused number 4 and with any of the accused. Further, the accused number 3 and 5, who were similarly situated with the respondent accused number 5, 4 were not charge sheeted. So there were some other persons who were also arrested along with them. So these persons were not charge sheeted. The case did not proceed against them. See, though charge sheet was filed on 29/12/2020, till the date of hearing the application, charges were yet to be framed. After that, also there were as many as 105 witnesses, and it was unlikely that the trial could be concluded soon. D, the allegation of prima facie case must also be matched with promptitude in the prosecution to establish the guilt of the respondent accused number 4. This is very important, Your Lordship. They say there's a prima facie case, and they delay in producing evidence. And from the month of September, Your Lordship, last year, no witness has been produced till date. And the case has been listed on a number of occasions. Every time the NIA fails to produce witnesses, it is listed more or less on a monthly basis, Your Lordship.
Yes, it is your witness. You are bound to produce
As
it.
Yes, Lordship, but as I also give my submission that there has been some delay, but as I already said, so there are some problem that witnesses have already at the time from by taking this statement as 161 statement, they are already they are willing to come, but right now some of them are not willing to come and give their statement. Some things, these things are happening.
Yes.
And
Then the last one, Your Lordship, the gravity of the allegations under the UAB Act 1967 must be balanced against the rights of the respondent accused number 4 in the context of the delay in prosecution and or non-prosecution, the period already spent in custody and the length of time the trial was likely to take on account of the delay by the NIA in prosecuting the case. So these were the grounds which were urged before the learned trial court, and on the grounds that on these grounds the learned trial court was pleased to grant bail to the accused. And as the Lordships have already observed, and as the NIA has also admitted, the accused, the respondents have not violated any of the terms of the release on bail. Now, Your Lordships, as far as the ground of delay is concerned, there are already 2 decisions by this Honorable Court. Same grounds taken by the NIA in questioning the release of the accused on bail. And this Honorable Court, coordinate bench of this Honorable Court has already held that delay in the prosecution of the case is a ground for releasing the accused on bail, and there is no cause for interference. 2 decisions. The first one is in the case of Criminal Appeal 1 of 2021, Your Lordships. This is NIA versus Victor Su. and Victor Su. Worships may see from, there has been a discussion of the cases on the issue of bail under the UAP Act, and Worships can come straight away to paragraph 15 in the case of Victor Su. Paragraph 15. Paragraph 15. It is a fact, if I may read my notes, it is a fact that in the case in hand, the accused has been charge sheeted and the charges are also framed against respondent accused, and 2 witnesses have also been examined by the prosecution side. So there is no ground to hold that accusation leveled against him is prima facie not true. And while granting bail to the accused, the learned court below has not recorded any findings to this effect. But we find that the learned court below has not considered the petition on merit. Even otherwise, this alone cannot be a ground to dismiss the bail application in view of the ratio laid down by the Honorable Supreme Court in Najib. In the said case, a 3-judge bench of this Honorable Court held is under. So this is about 43D, Your Lordship. As Your Lordships are well aware of that, no need to get into that. And paragraph 16. Here in this case, we have already held that learned court below, while granting bail to the accused, has balanced the gravity of the offence with that of the period of the accused had already undergone in judicial custody and the reasonable time required for completion of the trial. It needs to be reiterated here that the accused was behind the bar for 3 years and 80 days, and out of 126 witnesses, the prosecution could have been able to examine only 2 witnesses. This being a factual position, we are unable to agree with the submission of Mr. Mishra, the another counsel for appellant, and we are of the considered opinion that the ratio laid down in the Otali case, which is a decision of 2-judge bench of the Honorable Supreme Court, would not come into his aid in view of the decision in Najib, which is a decision of 3-judge bench of the Honorable Supreme Court. Rather, we find force in the submission of Mr. Paul, the learned counsel for the accused, and the ratio laid down in Najib fully endorse his view. We have also gone through the other case law cited by Mr. Mishra, and we find that the same will not come to his aid, and therefore also for the sake of brevity, we are not inclined to burden this judgment with elaborate discussion of the same. As already indicated, there is no whisper in the memo of appeal about violation of any terms and conditions of bail by the respondent accused. And during hearing also, the legal counsel for appellant has not whispered a single word about violation of any terms and conditions of the bail by the accused since the time of his granting bail till the date. It is worth mentioning in this context that while dealing with cancellation of bail, the Supreme Court in the case of Raghubar Singh reported in such and such held that bail can be cancelled where on the grounds on which bail can be cancelled. Then next page, 19. Again in the case of Mayakala Dhamarajam arising out of SLP such and such, it is held that it is right law that cancellation of bail can be done in cases where the order granting bail suffers from serious infirmity resulting in miscarriage of justice. If the court granting bail ignores relevant materials indicating prima facie case involvement of the accused or takes into account irrelevant materials which have no relevance to the question of grant of bail to the accused, the High Court or the Sessions Court will be justified in cancelling the bail. Not the case in this application. Here in this case, none of the aforesaid conditions shown to be existed by the appellant side. Of course, we are not oblivious of the fact that we are now dealing with an appeal preferred under Section 21(4) of the NIA Act and not a petition under Section 429(2) of the Act. But the appeal is preferred against the bail order, and allowing the appeal would have the consequence of cancellation of bail, and therefore, while deciding an appeal, we are constrained to take note of the well-established principles in the cancellation of bail also. In view of the above decisions and findings, we find this bail bereft of merit and according to the same stance dismissed. The parties have to bear their own costs. This is one in Lordship. This is the Victor case. Now, in the other one, in the Saka case, more or less on the same grounds, Lordship. It's a short judgment. Same ground taken by the NIA in this case also, violation of 43D, 5 and 6. That was dealt with. And on the ground of delay, the order allowing bail was not interfered with. Now, after this, Your Lordship, in the recent case of the Supreme Court, Your Lordship, it has not been reported, but it has been it has been widely publicized. Even in the case of the NDPS, and the Supreme Court has held time and time and again that the NDPS is an act which is more severe than the UAP Act. Even in the NDPS Act, if there is a delay in the prosecution of a trial against an accused, the accused is entitled to bail. In the NDPS Act, Your Lordship will appreciate, the accused must prima facie prove that he is not guilty. Then only he is entitled to bail. which is a much more stringent provision than a prima facie case, which the NIA has approved. In the NDPS Act, the accused himself has approved that
Can
he
we
is
have
prima
that
facie
citation?
not guilty.
Sir Ejimobi, can
Yes,
we have
Madam.
that citation?
Uh,
The latest Supreme Court.
It is Mohammed Muslim versus State of NCT. It is a worship. It has just been recently uploaded into the websites. I can print
Can
it
you
and
kindly give
I
a
can print
printout copy
Yes, my lords, I can do that.
to both of us?
Yes, my lords, I can do that. And then again, there is another case, which is the SK Until case, which deals with penal provisions under more or less all statutes. SK Until. This is 2022, 10 SCC, page 51. Give a citation. Lordship, actually, earlier I thought the matter would not be taken up by the court, but what my learned friend was telling me, so I did not place the list of authorities.
2022 10 SSC, page 51.
Page
Correct?
51.
Yes, what is the law lead down?
Your Lordship, here the Honorable Supreme Court deals with section 41 and various categories of cases under category A, B, C, and D, depending on the nature of the offense. So category A types of offenses are
Relevant paragraph, Mr. Ejimobi. Paragraph.
many paragraphs. Your Lordship. Paragraphs 72. Paragraphs, first of all, the category of cases is mentioned in paragraph 2. Paragraph 2. Then the UAP Act. UAP Act comes in category A. Category A. Category A.
Para 2, category A.
Yes. UAP Act. Offenses under the UAP Act comes under category A. And you will find that in paragraph 2. And then relevant paragraphs and worships will be paragraphs 72, 84, 92,
72, 84,
92,
92,
115.
115.
Oh, that's a page number, my lords. The paragraph numbers, sorry, my lord, I'm giving you the page numbers. Paragraph numbers will be 2, 27.
Just wait, paragraph
2, 27, 40,
40,
48 to 50,
48 to 50,
62,
62,
66,
66,
87,
27,
87, my lord.
87,
88,
88,
93,
93,
94.
94.
And in this case also, your lordships, the Supreme Court says that delay, even in UAP offenses, the benefit must go to the accused. So shortly, your lordship, that is the principle laid down. And the Supreme Court case recently, in the NDPS case, I'll print it out. And,
Yes, please print out and give us copies each.
Yes, my lord. So my humble submission, my lords, is that in both the appeals, the only ground taken is 43D. Nothing else. 43D, if there is a prima facie case, the accused is not entitled to get released on bail. And that has been overlooked by the trial court, especially NIA. That's the only ground taken. And that ground has been revisited now, essentially. And that ground in the appeal is no more a valid ground to challenge an order enlarging the accused on bail. That's
In
the
view of
humble
which decision? In view of which
the decisions relied upon, your lordship, is the 2 division bench judgments. It's all the decisions are mentioned there, your lordship. Then the latest one is this SK Antilka case and the decision of the Honorable Supreme Court in the NDPS case. That I will place before your lordship.
it been finished? Has it been finished? This is yes, second. Which judgment you will be pushing us to copies?
That I have not mentioned here, Your Lordship. The decision in the NDPS Act that has come out recently. That I will produce separately. I will furnish it.
Yes, please.
So, Your Lordships, in the Watali case, which is the case heavily relied upon by the NIA, the Watali case laid down a decision that if there is a prima facie case, there is no question of releasing an accused on bail. After the Watali case, there has been a series of judgments by the Honorable Supreme Court, and that provision, that principle has been revisited. And the position now, if I may humbly submit, Your Lordship, is that if there is a delay in the conduct of the trial, that itself is a ground for release of the accused on bail, even in UAP cases.
Have you given us your citation?
Chief, I will give you, actually I have only one copy.
You brought it for yourself only, not for us.
No, Lordship, actually I didn't find.
What is the citation?
Criminal appeal number 704/2024, special leave petition, Gurvinder Singh versus State of Punjab and other.
You can give the copy.
I have highlighted.
You kindly give him the copy for the state. No, you. This is for which judgment? Which judgment relied by him? Huh? Oh. This you are relying on which case?
Gurvinder Singh versus State of Punjab and other.
No, this is not the case.
Those are my authorities, Your Lordship.
Okay.
In my list of authorities, I relied on some judgments. Your Lordship,
This Krishna Satya death.
yes, my lord. This case is a very interesting case, Your Lordship. This is a case which originated from the state of Nagaland. And this is a case where government servants were put in fear of their lives, and then money was demanded from them. Basically, extortion, Your Lordship. Now, this case went up to the Supreme Court. The NIA took it up to the Honorable Supreme Court, and the Honorable Supreme Court says, for the purposes of bail, if it is an extortion, it does not come within the scope of 43D. If someone has been subjected to
And
extortion.
this criminal appeal baron, this is the case you are relying.
No, this is a different one, Your Lordship. This is
Different
again-
one.
Yes, Your Lordship. This is again on the ground of delay.
Okay.
On the ground of delay. You know. That I have placed a printed copy, Your Lordship. And in the case of SK Until, which is now before Your Lordship, SK Until, I have referred to many paragraphs, Your Lordship, but just paragraphs 87 and 88. For the moment, Your Lordship, just paragraph.
Which
87.
case?
This SK Until. Paragraphs 87 and 88. And in my list of authorities, I have culled out the principles, Your Lordship. In my list of authorities, which I have furnished to Your Lordship. Paras 87 and 88.
87, 88. SK Until. Para 87. Para
87 and 88. These are lengthy paragraphs, Your Lordship.
Yes. Okay.
Lengthy paragraphs. But the principle I have mentioned in my list of authorities.
87.
87 and 88.
This precedence.
Yes, my lord. And the principles laid down in this proceedings. Yes. So 87 says, my lord, a timely trial would not be possible, and if a timely trial would not be possible and the petitioner has suffered incarceration for a significant period of time, and therefore the courts will ordinarily be obligated to enlarge him on bail. 88, the principle is refusal to bail on the one hand And to delay trial of cases, on the other hand, is clearly unfair and unreasonable and contrary to the spirit of Section 36(1) of the NDPS Act. So here, NDPS Act is again more severe, Your Lordship, as far as the provisions of bail are concerned. And this SK also notes that fact.
How long was the accused under detention prior to his release?
About 2 years. And after, by the time the bail application was heard, about 2 years. Both accused. I have mentioned that in my application, Your Lordship. In my written objection. Your Lordship may find that in page 3, Roman 5. After the framing of the charges, witnesses were summoned to the process of court on 6/5/22. The first witness in the case, P number 5, was examined on 17/6/22. From the date of his custody to this date, over 2 years had passed. When the first witness was examined, over 2 years had already passed.
So far, how many prosecution witnesses have you?
5,
examined?
only 5
5.
Out of
105.
Lordship, in our appeal petition, we have also mentioned that the accused number 4 is in associates with top leader Self-Style Cornell.
That is your charge. It is yet to be proved in the court of law.
That's why
We are now on bail. We are now on bail.
I agree.
Not
that,
on the
Lordship.
merit.
I agree.
We
that,
will not
but,
go into the merit of the case.
But by seeing in the judgment, I'm referring there, it is been clearly mentioned.
The position which you are taking now should be taken before the trial court. Whether he is in association with the top rung leaders of any organization or not.
Since the trial court have not considered our ground and granted the bail, so that's why we approached this honorable court.
And the law has laid down certain parameters under which bail should be granted, under which bail should not be granted. We are confined only to that.
Since the learned NI court did not consider our grounds, so that's why we appeal before your lordship.
Yes, Mr. Jammu.
So that is the first case, Your Lordship, and the second case is also related, same grounds.
Same. Is it same?
Yes, my lord.
Second case also same.
Second case is also related to same FIR and the same
Same FIR, same
different accused.
proceedings.
Accused is different.
That's all.
Here he is the
Same sections.
Yes, ma'am. Sections
no,
are
no,
different.
Lordship.
Sections are different.
Accused 4 is charged with section 17 and 18 UAPA, and accused 1 in criminal appeal 4, he was charged under section accused number 4 in 3 120B IPC 17 and 18 UAPA.
Okay, let us complete this appeal 3. Let us complete this appeal 3. Let us not get confused. Yes, any more submission? Mr. PP.
Lordship, I'm just relying on the judgment. Let the judge be completed. And, regarding our appeal, the accused 4 is being charged of taking extortion in relation, in associate with accused number 1, who is in criminal appeal 4. And that's what I'm trying to give submission, Lordship. Who is self-styled Colonel NSN IM.
You only submit us, you only satisfy us as to why bail should not be granted.
Yes, Lordship.
That is the issue
And-
before us. We are not
and-
unmarried. We are not unmarried.
And in our criminal appeal petition, we have also mentioned in page 16 that accused for as any secret movement and illegal activity of the respondent accused for could not be traceable due to his link with other members of NSN IM.
You could not trace the allegations. That is what you
We are
need to say.
unable. We are unable to.
You are unable to trace the allegations.
No. Right now, since he's been on bail, so we are unable to trace his links with the other members of NSN IM.
You had over 2 years. You had over 2 years. You could have actually taken
They
him
even
for
took an
interrogation.
extension. They even took an extension for investigation.
You could have taken him for investigation, even when he was in jail custody. You could have taken him for investigation, of course, with the permission of the court.
Yes, Lord.
Now, I think maybe all this may not be relevant at this stage. Which paragraph you are relying? This Gurvinder Singh? Gurvinder Singh, which paragraph you are relying?
Actually, in the last page, last and the second last page, I have marked here.
Oh. Achha. This is if there is every likelihood that he will influence the prosecution witnesses. That is,
Yes, sir.
you have nothing to say on whether he has influenced the prosecution witnesses as of date or not.
But there is every chance of influencing.
No, don't take that ground. You are making a submission before us. Don't take that there will be
No,
apprehension that he will do this, he will do that. That is your apprehension.
Yes, Lordship.
We cannot take that into consideration. Yes, anything more else?
No, Lordship. Humble submission before your honorable court to kindly cancel their bail application and pass the impugned order dated 13/6/20.
Mr. Ijmoni, even the second case, the charge sheet, everything is same.
The same, the
Charge
same.
sheet, everything.
Just the
is same.
sections
Only
are
thing is
different.
that actually the names are different and different
Sections are
sections.
Together here in this case, how many accused are there?
Together, Lordship,
17.
1 second, Lordship. In the first charge sheet, there are 6 accused and 3 are not been charge sheeted.
Out of 6?
Lordship will.
Out of 6?
No, Lordship. 6 accused have been charge sheeted
Okay.
and 3 are not. The Lordship will find in page number 41 of criminal appeal.
Page-
Copy of charge sheet.
Page,
It is,
page 41 of your appeal.
Yes, Lordship.
Page 41. Okay. This is that will be in page 42. Particulars of the accused person's charge sheet.
Yes, Lordship.
Correct.
Yes, Lordship.
So total 6.
6 have been charge sheeted And in page 45, Lordship will
Yes.
find
Particulars of accused persons not charged sheeted.
not charged.
Para 12,
Hmm.
serial 2.
So how many of them are still inside?
All on bail.
All
All
are
on bail, okay. So you are not challenging the bail granted to the other accused persons.
So these are the accused who are mainly involved in the extortion and
May I clarify, Lordship? Against two of the other accused, bail was granted to them. The matter was taken in appeal in the principal seat. The matter, after hearing, the bail order was cancelled. The matter was remanded. That application is pending. It was remanded by the division bench, by the honorable division bench. So that application is still pending.
Before this court.
No, before the trial court.
Okay.
It was remanded to the trial court. I'll finish the decision of the Supreme Court in the NDPS case during the course of the day. ma'am.
Yes.
Yes, anything more, Mr. Yukinoro?
That's all. ma'am.
Yes, anything
no
more?
Lordship. I've
Okay.
submitted.
Mr. Your good name?
D. Bharadwaj.
Mr. D. Bharadwaj.
Bharadwaj.
Learned, special,
Learned PPNIA.
learned PPNIA, and for the appellants, and Mr. H. Momi, the learned counsel for the respondent accused. Stop. Heard the parties at length. Judgment and order is very nice. In both the cases.
Very much.
Okay, same order in the next case. Same order in the next case.
For hearing item number 17.
Much obliged.
Lordship.
Yes, please.
Lordship, for item number 17, I beg to adjourn the case for matter today because actually we have not provided the file.
You are NN Mishra.
No, I'm D. Bharadwaj. And then Mishra his term has been completed.
Okay.
So I'm newly appointed for NI.
Okay. Mr. D. Bharadwaj, learned counsel for the appellant, and Mr.
Very so.
So and so, learned counsel for the respondent accused. Stop. On the prayer of the learned public prosecutor, NIA, the matter stands adjourned for 2 weeks.
Lordship, may the matter fixed on 12th of June.
Listed on
12th of June. I think that is also Wednesday.
listed on 12/6. 12/6, 2024. Okay.
It is the Wednesday, Lordship.
Wednesday. Yes, 12/6. Yes.
Obliged, Lordship.
For hearing item number 18.
Yes, Mr.
Please, your lordships. Lordships, I'm challenging the service rules of the Department of Home Guards. My lords will kindly appreciate this fact that it attracts Article 21, a violation of Article 21 because the
Mr. Joshua, if it is a lengthy hearing, maybe this will be the last day this court will be sitting.
my lord. Okay,
So you can take the earliest chance next week.
your lordship. My lord.
And next week we have a very good judge. Justice assignment.
My lord.
Okay.
Your lordship.
This is item 18,
Yes, your lordships.
listed as a fixed item on 22.
My lords.
Okay,
Your lordships.
on 22/5/2024.
Oblige your lordships.